Hello and welcome to the Modern Divorce Navigator live Q&A. My name is Billie Tarascio. I am an Arizona family law attorney, and the Navigator is part of an online total support group run by attorneys and social workers here to support you. Now, even though I'm an attorney licensed in Arizona, I do not become your attorney by answering any of your questions here on this live. And because it is live, I would encourage you not to share any confidential information that you don't want made known. Let's see, what else do you need to know? That's it. I don't become your attorney. There's no attorney-client privilege or confidentiality, but I am happy to help you today, however I can, brainstorm ways to do things on your case. So welcome, and Andy, how can I help you today?
Hi. So I have some questions. So I've used you guys before. I worked with Hannah on an amendment and stuff. Our divorce has only been final since October.
Hmm.
So yeah, still kind of like navigating everything and like learning to co-parent with each other. Um, right now, what my biggest thing is we just got I can share whatever I'm comfortable with, right?
Whatever you're comfortable with.
Okay, I just want to make sure I'm not like like causing any issues. So my youngest son just got an autism diagnosis on Monday. So I've had him in speech and OT since he was two, like since he
Mhm.
turned two.
Mhm.
And I've kept up with like all the services. I've taken him to all the specialists. At one point even when we were married, I was on FMLA to like manage all of his appointments and all of his care. Um, so I had told him like ahead of his birthday, his turning four, because they have to be four before you can do like the full eval. So starting in January, I notified him of all of my concerns. I didn't get a response. He didn't respond to either sped teacher for the IEP at school, and so they didn't the pediatrician. He responded to the clinician to receive a referral. He didn't show up to the pediatrician appointment. I notified him that I did get a referral for a full developmental evaluation, and he didn't respond. And this is all through the OFW app. And I should preface that we have 50-50 joint decision making with me having final medical decision making.
Okay.
And it's like a 60-40 physical schedule.
Okay.
So I had mentioned it like I tried not to engage verbally at like drop off or pick up because he's high conflict. And so I just said, hey, like you haven't responded to anything. I just want to make sure that like you're good with this, and it's whatever you want, whatever you think you need to do, whatever you want. Um, so okay, so I moved forward. I scheduled the appointment. Gave him all of the information months in advance, encouraged him multiple times to be there. Um, he said he didn't want to go. They even changed the appointment so that it went from my custodial time to his custodial time. And he said, not a problem. I can take him and drop him off, or you can come and pick him up. He ended up bringing him to my work on his time, and then I took him to the appointment and then dropped him off afterwards. So he's consenting this entire time. And then we get the autism diagnosis, and he is off the rails. And like saying he didn't consent to it, and does not consent to therapy, does not consent to treatment, and that all of a sudden I'm a monster and I'm doing this to get resources for myself and not for my son. That I'm making all of this up, like just he's been blowing up the OFW app like nonstop. And so um I don't know what to do, because I know like when I had spoken with Hannah initially, she had told me they don't really do modification in the first year.
Nor do you need
So like,
one.
okay.
Nor do you need one. You have final medical decision making.
Okay, so like, is that it? Because he's like, no, you don't, no, you don't. He's like, we have joint decision making. I'm like, it's marked on there, like on the paperwork that I have,
Yeah.
like it says that I have final say for like all major medical. It's like
Yeah.
the top of page 6, I think, on like the parenting plan.
So you're fine. You are doing everything within your legal authority. You have done absolutely nothing wrong. He cannot
Okay.
withdraw consent after the fact when he doesn't like a diagnosis. He just can't.
Okay. Okay. Well, I'm like taken for a second opinion. Like, you know what I mean? Like,
That is
he's not tried to.
exactly, yeah, what I would recommend is that you need to write up one thing and tell him, like, this is the last time. I'm not going to have the same conversation again and again and again, okay?
Yeah.
I'm not going to do that. Here is what's happened. Here is where we're at now. I understand that you now are asking and lay it all out. You don't want him to go to therapy anymore. I understand why, and we're not doing that. We're moving forward with therapy. Like, I'm
Okay.
exercising final legal decision making, and we're doing this. However, if you want to get a second opinion, I would be happy to participate. I would be happy to support that. Happy to look at alternatives. But no, we're not going to stop therapy.
Okay. Well, and so he's saying it's like because I don't have final say for education, and
Mm-hmm.
so that's where he's like because it would change schools. I mean, he's already at the Advantage preschool getting services through the district, and so like
Mm-hmm.
that's already happening. And now he's saying like because I don't have final say education, he's like I don't
Mm-hmm.
support that. Like you're not switching schools, you're
Mm-hmm.
not like getting him services through ABA.
Mm-hmm.
Like that's where he's using that authority, and
Mm-hmm.
I don't. I've never been through this diagnosis. I've never,
Mm-hmm.
like I have three kids and like he's my youngest.
Mm-hmm.
So this is all new territory for me.
Mm-hmm.
So I'm not really sure I even understand like at what point I can be like, thank you for the feedback. This is what we're actually going to do.
Yeah, I think you're okay. I think that that's what I would do. I would tell him, listen, this is not a educational choice. I'm not deciding to send him to this school because I like the school better, because it's more convenient, even because I believe that he has to be educated there. This is directly related to his doctor's recommendations, to his professional's
Okay.
recommendations. That is directly related to his medical condition.
Okay.
That's how I would do it. I would put the ball in his court to go get a modification and show that somehow you're out of line because you're not.
Okay. Thank you. Well, because I'm like, do I just automatically get a lawyer and like, try to like, sorry, I think I'm like going in and out of service here.
You're okay.
Did I lose you?
Nope, I'm here. Are you there?
Okay. Yeah, okay. Sorry. Yeah, so I just wasn't sure if I needed like legal representation at this point or if I'm just okay to like just keep on pushing along and do what I can. At what point would you say that I should um like kind of look into that?
You may need some, or you may benefit from some legal coaching, kind of like what we're doing
Okay.
now. So
Okay.
if you're not already a member of the Navigator, join that. It's
Oh, I
just
am. I am.
you're
Yeah, yeah.
okay, great, great. Because
Yeah.
then you can come to these once a week and we can talk about it. And
Right.
if that's good
Okay.
enough, great. If you feel like you need to have a lawyer like Hannah or somebody else that is hired on a limited scope basis just to be there for when you want to check in. Hey, we read this. He sent this to me. This is my proposed response. Is this okay? Just to make sure, because I know it can be very scary when you know this is going to be used against you in front of a judge. And you just want to make sure that
Yeah.
you're saying the right thing.
Yeah.
There's
Yeah,
nothing
I
wrong
try
with
to sorry.
hiring a lawyer to help you with that piece only and not retain them to go to court. You can do that.
Okay. Yeah, I just try to keep it all like factual, like, you know what I mean, and try to leave the emotion out of it and then let him go on his tangents of things. And learning not to respond to
Right.
all of it. It's hard when there's like so many false allegations. It's like you just automatically jump to like want to defend yourself. And so I'm learning that like I don't have to do that. Like, every time it's really hard.
Yeah.
Um, so I guess just keep on moving and just keep documenting, and then once we can do modification, I guess go for that. So like for modification, if I want to file for that, um I had a question because I had posted this in the other support group, and someone had mentioned House Bill 2296 that just passed, I guess like March 5th. And so I just was wondering if you could kind of like weigh in if you were familiar with that,
I'm
or
not.
anything.
I would have to go look it up.
Okay, she was just saying that that was like her, like what helped her in her case to get like more custody, showing that like because of medical necessity it made more sense that she had physical custody. Um so I just wasn't sure at like what point do I have to wait like a year to the day to file for modification, or do I just wait to get a trial by that year date, or how does
Mm.
that?
You can't file for a year unless it's an emergency.
Okay, so
So
just wait.
right now, decision making wise, you have everything you need. You honestly do. But if
Okay.
you find that the
Okay.
parenting time is not working and that the parenting time is no longer in your child's best interest, then that is when you're going to want to request a modification. But you probably will have to give him a year, which makes sense. You're going to need evidence, and the judge is going to want to see before you go in and you say he can't take care of him. We have this diagnosis, dad can't do it. We
Right.
need evidence that dad can't do it.
Okay. Yeah, or that he's like refusing or
Exactly. Or whatever.
okay.
Whatever it is that necessitates you having more parenting time.
Okay. Well, and like the thing is too, so like for school and stuff, since it is medical, is do you know like would he be required to still take him like on his
Oh yeah.
days or
Yes, yes, you have to
okay.
take your kid to school. Yes.
Okay. Well, he's only 4, so it would be like a preschool program where
Mm,
he would receive like one-on-one
mm.
services.
Okay.
So I wasn't sure if it was like if it's Monday, I mean, because it's like Monday through Friday,
I
and
see.
then they would still provide transportation for him to get to and from the Advantage preschool that he's already doing through the district. Plus, they would give him that one-on-one, for speech and OT or whatever other services he needed. So they would provide that there. So I wasn't sure, like, can he just say, well, I'm not taking him on my time? Or can I say, because this is medically necessary, like, you're still required to?
Yeah. So there's no law, covering what you're asking,
Okay.
right? Because it's so specific. There is no
Yeah.
law on this. However, your perspective is legitimate and legally defensible.
Okay.
So
So just stick with
you
it.
may want, that may be another thing where if you want to hire a lawyer, limited scope, they can help you write a letter to him saying like, you got to do it. And with what
Okay.
you just described to me, it sounds like it's not any more hardship on him. You're not asking him to do something impossible. You're not asking him to drop his job and stay home and take your son all day, every day, someplace, because that would not be
Right.
reasonable. What I'm
Right.
hearing from you is that the state is providing the transportation. Nothing changes on his front.
Hmm.
He just has to not get in the way.
Right. Right. Essentially. Yeah. I'm not asking for financial compensation. Like,
Yeah.
I'm not asking for anything, just to make sure that he's getting the services. I don't have to schedule the appointments outside of school now. They will go and
Mm-hmm.
do them there.
Mm-hmm.
Um, so it seems like it's in everybody's best interest, but he is like not on board. So,
Mm-hmm.
okay, well, I will keep
Thank you,
documenting.
Andy.
I'll keep pushing forward. Thank you for that. I appreciate your input.
Yeah, and if we have more time, I can come back. But I want to make sure
Okay,
it gets to everybody.
absolutely.
Nicole, how can I help today?
Hi.
Hi.
So we had trial on Tuesday,
Okay.
and the petitioner showed up. Well, he appeared by phone,
Okay.
um, fraudulently.
What?
So, yes, the power of attorney called in
Mm.
on Court Connect.
Mm.
He called her on her personal phone,
Mm-hmm.
and then they did like this phone thing. So he was speaking through the third party line against
Interesting.
prison policy. Obviously, now we have like a participating party who is not legal counsel, which was outlined in our minute entry and the ruling to set the trial. So that wasn't brought to light until after trial. And the
Okay.
judge reset the trial for the end of May
Because of
because
that.
what?
Because of that.
Because the petitioner showed up. Um,
Oh, okay.
to say I was crushed is like an understatement. Um, Previously, the judge had said no evidence needed to be admitted, no pretrial statement, nothing. Then we get there, he shows up. He's like, "Well, I have no evidence. I have no pretrial statement. I have no trial brief. I don't know what you people want me to do." Okay. So we got the minute entry, and now it's saying that we must meet face to face. Like, I feel like that this might be working in my favor, but that we must meet face to face no less than 10 days prior to the trial, and a mandatory joint pre-trial statement must come out of that. That's not going to happen.
Okay. So those are boilerplate orders that frequently don't happen.
Okay.
And there probably won't be a consequence to those things not happening. But you may want a lawyer to draft a motion for you to the judge because you met the requirements to get a default.
Yes.
Okay?
Okay.
So he didn't respond in time. Then he shows up after the fact. The law still allows you to be granted a default.
Right.
So that's something you should consider.
Okay. The other question I had was, I've already requested the public records from the prison of his phone calls to show that he did not, in fact, call Court Connect, that he had called her at that time. Is that worth bringing to? No, it's not.
No.
Okay. The default is probably the better option.
I think so. I think the default is the stronger legal argument. So if he showed up, but he didn't show up the way the court told him to show up, but the court was fine with the way he showed up, there's not going to be a consequence.
Right. Okay.
But if the law required the judge to grant you a default,
right,
then him showing up incorrectly after the fact through the third party, now I feel like that has a little more teeth.
Okay. All right.
But that sort of has to be a legal brief, and that might be one of the times when it does make sense to hire a lawyer to research the issue, to write it really well. Even if you're still filing it yourself, they can ghostwrite it.
Mm-hmm. Okay. Is that something modern law does?
Oh yeah, for sure.
Okay. All right. Thank you.
Sorry that happened.
It happens. I mean, it happens, I guess. So we just keep going forward.
We just keep doing it. Thanks,
Thank
Nicole.
you.
Sarah, how can I help you today?
Hi, Billie.
Hi.
Hi. So I have two cases going on, and I just have a couple technical questions. In the one, we're really close to settlement. However, some safety things popped up that I've been talking to his attorney about. Are regarding, like, we're in Arizona, so it's regarding a baby or a pool gate around a pool, that type of thing, which I think is very needed when you have an 18-month-old baby.
Yeah.
So regardless if we reach settlement or not, our case currently, as of when you look at it, it's on the dismissal calendar until April 1st.
Mm-hmm.
Although I haven't checked the ECR this morning. So I did receive yesterday on the ECR, I received notification that my request for mediation was finally pushed through. And I requested that like a month ago. Courts are a little slow. So they ordered that. Do I need to file a request to extend on the dismissal since it's
Yes.
Okay? I'll get with his attorney on that. So it's probably cheaper if I do it. That was my first question. Second is, if this pushes through towards trial, if I'm going to submit transcripts of our emergency order as, if I get him to testify that he lied on the stand, do I need to submit that as in disclosure?
Yes.
Okay, same rules. Okay. Now, in my other case, I'm not pro se, but I could be pro se anytime. Have you ever encountered somebody doing a pro se depo?
Yeah, you're allowed to take your own deposition.
Oh, perfect. And same thing, I just hire a recorder and do it in their office, or find do it in, right?
Yep, absolutely.
Perfect. I've been through a lot of depots, and I'm pretty sure. What's the allotted time in Arizona? Like 4 hours?
4 hours.
Yeah, I can
4
get.
hours. We should add a course to the navigator on depositions, how to defend them, how to take them, how to prepare for them, what the rules are, because it is a little specific, but you can do it.
Yeah. And I mean, once you go through one or two, you're pretty numb to them. So I've been through 6, both through business and family court. So
Got it.
and I feel like if you've ever gone up against Matt Schultz and had to go through one of his depositions, you can pretty much handle one on your own. So
his reputation precedes him.
sure does. Okay, and then final question. I've had 2 children. 2 of my 3 with this case age out of family court. One that just turned 18. I have orders that I submitted back in 2022 that were still well, this is with Mr. Schultz, so he drags his feet a lot. So is it unheard of for my recently turned 18-year-old to testify in that family law case?
Where he is the child of the marriage?
She is the child of, yes.
Okay, she the 18-year-old. And the case, is it a custody case? Like, what's the issue?
So it was over parenting time. It's parenting time and contempt for, he owes me a lot of money. And I haven't done a recent arrears because, that system's down right now.
Yeah.
So previous 50,000. And then the last order, we have our 20-year-old is special needs. So in 21, he took me back as an emergency hearing was found misleading. So the judge ordered him to pay for my attorney fees, which, is like, he has the money, but he doesn't want to pay it. So it's a request. It's a motion for contempt and change of parenting time regarding it was supposed to be our oldest or middle and our youngest, but now it's just our youngest because he's 16. So it's a motion to change parenting time, all that stuff. So
I don't think that you can be prohibited from calling your 18-year-old daughter.
Okay.
But this is a big but. This is so strongly frowned upon in Arizona courts that I would not recommend it. If I were your lawyer, I would work really closely with you to figure out a different way to get the evidence in.
Okay. What about
even if it's her opinions? I would figure out a different way to get that in.
That was my request, is a sworn statement that's notarized by her.
I don't like that.
No,
You're now involving your child. Yes, I understand she's 18, but you're involving your child in litigation between her 2 parents. It's like the cardinal sin. You don't do it. Unless, did she see something that nobody else has ever seen that is so critical? You know what I mean? Like, there would have to be such a strange set of circumstances to make that worth it.
No, it's not abuse. It's just his, he's been like positioning himself in family court for the last several years that he's had, that he has the kids half the time, and it's never the case. Like, we go through and he files an emergency thing here and there, and then we go through that because that's quicker. And the minute that order is signed, he goes back to not taking his kids. So the only thing that she would provide is that this entire time she hasn't been in his care. Like, he doesn't pay for anything minus his measly child support.
Okay. There has to be another way to get this information.
Okay.
Maybe it's cell phone data.
True.
Maybe it's location tracking of your kids through Life 360 or a different app that they have on. Or if there's Apple Find My Phone, like, there has to be another way to show this that is irrefutable, not opinion, not, there's just got to be a way.
Well, and I was there, I think when I tally everything up, like taxes, I filed taxes even though we're supposed to divide because they've been in my care and he's in arrears. So I filed taxes, refused to fill out her FOSFA form. And he sends me messages saying, you need to do it because she lives with you. So those
perfect. You already have what you need.
That's what I mean. So I was just wondering. I mean, I wasn't
It's
want
a
it.
fair question. I'm glad you asked.
Because my daughter, she feels like this entire time she's had no rights, and now all of a sudden
Right.
she's 18 and she has a voice.
Right.
Like the
Right.
family court's a little bit different,
Right. I
So,
hear you. Absolutely.
well, those are my questions. Thank you.
Yeah, you're welcome. Lisa, how can I help today?
Hi.
Hi.
I just want to say, first of all, thank you so much for having this amazing platform because it's been really helpful. So I'm happy to meet you in person, online today. Um, so I'm in Chicago and Cook County. So I've had to go all the way to Arizona to get this information because it's been really hard being pro se.
Mm-hmm.
Um, I've learned a lot and from your podcast. But my question specifically, and I'm not sure if I'm in the correct forum for today, is this just to ask specific questions related to a case?
You can ask whatever you'd like. I'll try to help you the
Oh,
best I
okay,
can.
fantastic. Well, I don't know where to start. I suppose I'm in carpals right now, waiting to see an attorney here to help me. But I've been pro se, and I'm just trying to figure out whether if it would be acceptable to file a motion to consolidate and advance hearing dates to have a scheduled uh, April 10th hearing date with the presiding judge, who's been on our case for over 2 years now. I filed an emergency uh, petition just for parenting time and to reinstate the GAL. About a month ago. Oh no, January 15th to be exact. So that emergency hearing was heard by the judge. She did suspend the parenting time and reinstated the GAL. The GAL has been on the case. He has advised and cooperated that the child is fearful of going to her dad's, and so and has recommended a therapist, child therapist. So she has been seeing the child therapist. She's been with me 100%. This is a post-degree case, which we had 50-50 after 2 years of divorce and tons of litigation and mediation. We had 3 mediators. Unfortunately, during COVID, we've gone through 5 judges, and there has also been a order of protection that I petitioned for but did not get because of 2 years of of being in court. There was a GAL that was put in my daughter's care for she's 12. She was 10 at the time. It's been going on for 2 years where I was trying to get the order of protection and everything heard, but my ex-husband, I've been suffering from narcissistic abuse, but he was just gaslighting and just putting out these false allegations to the GAL and having him on his side, basically, because the GAL would say, you need to send her to this and that. And it was all on my parenting time. Like, I didn't even we agreed that she was going to do this. And so I was being inundated while working full time, while trying to take care of her because she had special needs, social, emotional needs from all this craziness. And in the end, I think if the GAL finally saw the light. Anyway, after 2 days of trial hearing for the order of protection, and the reason why I filed it was because he sent a SWAT. He called the police with a false allegation that I abducted my child and she was endangered. And this was right after school. It was on my
So,
parenting
Lisa,
time.
can I stop you for a minute?
Yes.
I know there's probably years and years of background, but
Yeah, sorry.
you started out with, no, it's not a problem at all, but you started out with the question of, should I file a motion to consolidate? Can you tell me what those 2 pending
Yeah,
issues are that you're thinking about consolidating?
correct. So since I withdrew the order of protection, we have now a mutual order of protection because he filed a cross order of protection, false allegations, but the judge and the GAL said, let's just do a mutual. So we did a mutual. The GAL said, well, we'll give you a order of protection if he violates this. And he has since 20 times. I've got it documented in evidence. He's Yeah, so and that was included in my emergency petition to the
Do you
judge, and
call
I
the
think that is
police
one of the reasons why she's suspended.
when he violates the order of
No,
protection?
that's the thing. So there is no order of protection in place. It's a mutual no contact order. I think I've
Oh,
just been really weak and not knowing how to do this right, being
okay.
pro se. So I've just kind of always like tried to cooperate and, settle,
Right.
but I can't do it anymore because he keeps coming, after me, harassing me and intimidating me, violating the court orders. I've had it. Like I have to. So I filed several filings. So what I'm just trying to understand is it okay to ask for a motion to consolidate and advance the hearing date when I have one for April 10th? I have an April 10th hearing coming up, and this is to hear his attorney who has filed a motion to amend the parenting time and the areas of responsibility. So we have four here. So he's asking for full, like it's so crazy. Like he's asking for full custody basically. And so his attorney filed an emergency for this to vacate her order. She denied it.
Yeah.
And
I would
yeah,
say
so that's a
so.
good step. I think that's a good step. And so then now we're going to be heard on April 10th, and I filed four filings, and I'm not sure if I should consolidate them because I did it through the internet. We have an internet system, so
Sure.
it gave me different dates, and they're all spread out.
I see.
So I'm just wondering. Yeah, I'm wondering if, and they only give you 5 minutes because it's all backlogged. So I'm
5
wondering if I
minutes
should
per
file.
issue?
Hmm.
Okay, that's not even going to be enough. Like, we've been talking for longer than 5 minutes. um, what are the four requests that you have pending?
Thank you. So I have a petitioner's response in opposition to the respondent's motion to modify allocation judgment parenting plan as to the allocation of parental decision-making responsibilities and parenting time. So that was my response for April 10th date. And then I have a petitioner. I have amended verified rule to show cause for contempt for his continued violations even after the January 15th suspension of his parenting time.
Okay.
I have also a petitioner's motion to modify the parental decision-making responsibilities. In the emergency, I have a motion to amend the parenting time, but I didn't put in the decision-making responsibilities. So this is why I have it as a third one here. And then I have a fourth one, which is petition for interim and prospective attorney fees and costs, GAL fees, therapy costs, fees, and modification of child support since I have 100% now since January 15th. And a motion to consolidate and advance hearing dates. I'm not sure if I'm putting too much, if I should spread it out and keep
I
it,
mean,
like,
you,
I don't
you
know.
have a lot of issues here. You have a lot of
Yeah.
issues. And it depends on how much time the court will give you. So, in Cook County, how much time will you be able to get in front of your judge?
Great question. So like when I've filed these filings, I've only been given 5 minutes. And so I have these dates all spread out into May. However, when we were last in court, the judge said she was giving a half an hour for my ex-husband, the respondent, his motion to modify allocation and parental agreement plan, because he wants basically full custody, saying that he's alleging that I have parental alienation. They wanted a half a day of trial, of hearing. They're bringing witnesses. I don't know who they are. They didn't mention. They wanted a half a day, and she said, and in person, and she said no, she wants it on Zoom, and she's only giving half an hour.
Okay. So, the downside of filing a motion to consolidate and requesting, let's say you request 90 minutes, because, he's asking to change parenting time and decision making. You're asking to change parenting time and decision making. You're asking to modify child support, and you're asking for attorney fees. I think you would file a motion to consolidate and you would ask for 90 minutes. Now, is the court likely to grant that? I would think probably. I would think it would be a due process issue or violation not to give you trial time. But you tell me, you've been in this for a long time. Like, will you get more time if you ask for it?
I guess it depends on the day. um, I, I don't know. I actually don't know. I think so. I do
Okay.
think. I
So
think
then
that would be
let's
a
say
possibility.
this works and you get your 90 minutes. Let's also assume that that is going to push your trial date out quite a ways until the judge can find a 90-minute block available on their calendar. Are you okay with that? Is the current status quo in your favor so that it's fine if the court hearing is pushed out?
Yeah. I'm just wondering why 90 minutes, because if the judge is only giving 30 minutes to hear their side, um, it makes me feel that she would rule against them as opposed to like in favor of the existing schedule until my child goes through therapy and, has wants to see her dad again. Um, so I'm not sure. Like, I guess this is my question is like, do I try to file it for the April 10th or do I push it out to the later date? My issues, like my responses. I don't know.
You can't do all of that in 30 minutes and do it well.
Right, right. That's what I figured.
So
Yeah, that's what I
it will
figured
have to be
as well.
pushed out. And is that okay?
I would prefer to have it sooner than later because I think I feel that he would use the time as a way to make more issues, falsifying false allegations as he's used to doing.
Okay.
But I think the GAL has he has a pattern of this, so I think the GAL sees that now.
So
Um,
do you think then that some issues can be consolidated and some issues can be set separately? Like maybe you consolidate
yes,
all of the kid issues, but you don't consolidate any of the money issues.
right. What do you think is best to do the kid issues first and then the money issues later,
It
or
depends
first?
on how badly do you need child support.
Yeah, I mean, it's not that bad, but there's there's GAL fees and there's therapy fees for my child, and it's all racking up, and it's like I should be the one paying for this because the whole reason, like I don't know, I'm just so confused. I'm just
Are you currently court
um
ordered to be responsible to pay for all of these fees?
no, I'm not. I am court ordered currently to pay for the GAL fees 50/50.
Okay.
Um, I am, and also the child therapy fees by a letter from the GAL, but not court ordered.
Yeah, that's not, the GAL doesn't get to tell you you have to pay for therapy.
Mhm.
So there's no court order that exists regarding uncovered medical expenses?
There's none. It's in my parenting plan and my parenting allocation that says that we should share expenses for medical.
And what does
That
that mean,
was,
share? Does that mean 50-50?
50/50. Like, yeah, because when we got the divorce, it was everything was 50/50.
Great. And is he paying 50-50? And are you asking that he be responsible for all of it?
Yeah, the majority of it.
Okay. And what is the likelihood that the judge will order that?
She hasn't. I've tried to petition for attorney fees and the GAL fees previously to fight this order protection case to bring it to court. And I mean, I paid over like $5,000 in GAL fees alone. I've just for his false allegations, and bringing it before the court. And that went on for 2 years and we went through 3 judges, and that's why I said, wait a second, what are we doing here? Like, we're here for the order of protection initially. And this is why the GAL was brought on board, but he just gaslit everything. It was just like bringing these false allegations. So it's like pushing this order of protection case until we finally had trial last summer. But anyway, what was my question? Yeah. So the GA, I did file a petition. I was pro se. He had an attorney. I've just been doing this all wrong. I've been doing it all by myself, basically. But I hired a criminal attorney to just for limited scope, and he didn't know much about the family law. So he was approaching it like a criminal attorney, which I guess is very different than family law. So anyway, I did not end up succeeding in terms of getting any of my attorney fees paid or the GAL fees. It was still like 50-50.
Yeah.
But, my finances have changed significantly since 2 years ago. And so
So
I haven't filed any affidavits or financials yet, but I guess I could because he makes considerably a lot more than I do.
and that wasn't the case at the beginning.
Right.
Okay, so if I were you, what I'd like you to do is go back and listen to this conversation because I asked you a lot of questions that will determine what your decision is. Because it is up to you, but every choice you make has potential consequences. So go
Yeah.
back, listen to the questions, think about the outcomes of those choices, and then you should be able to know with clarity, yes, I'm filing a motion to consolidate. This is what I'm consolidating, or no, I'm not. I'm going to handle them separately. Okay?
Okay.
Thanks,
Okay.
Lisa.
Thank you so much.
Absolutely. All right, I've got Yanni in the chat, or Yanni in the chat. What questions can I answer for you? And then if there's anybody else who's here who has more questions, I'm happy to answer those as well. Okay, it looks like we don't have more questions, so we can do a couple things here. We can have everybody participate in a strategic discussion like the one we were having with Lisa, where we weigh in, or with Andy, same thing, where we weigh in. What do you guys think? Pros, cons, options? These are all things we can do today.
I have one more question.
Mm-hmm.
So I also have our older son who is in therapy,
Mm-hmm.
like counseling
Mm-hmm.
therapy, just because since the divorce, he's just been like very emotional, like explosive behavior, and some things that I just felt like he needed some more support. So dad agrees that he needs therapy. We'll even take him to the therapy appointments. We'll take him on his time, but refuses to pay for half of it. And it's like it's ordered in our papers that he pays. I think it's like 54-47%, like the split for out of pocket medical. But he says he's not responsible for that because he doesn't like he consents to the treatment, but he doesn't consent to financially paying for it, and it's not medically required. Is that right?
No. No.
Okay.
He's just like your instincts so far, Andy, have been spot on with all of the
Okay.
decisions that you're making and the moves you're making. They've been spot
Okay.
on. And he
Girl,
is
it's because of you. I watch all of your videos. I read everything you post. I swear I'm like constantly doing research. I'm like, I need to go look at modern law. I need to go like see what Billy says about this. So like you're amazing. Like
you're
for
killing
our
it. You're
community, like
doing a
we
great job.
appreciate you. You're so helpful. Thank you. Thank you. Thank you.
I am so
Okay.
happy that it's been helpful because you are navigating this very, very well.
Okay. So I just keep adding the expenses, like just keep uploading the expenses to the OFW app. He can just project them. That doesn't matter. And then just tally up in a year when I go for modification or
Yeah, so you here are your obligations for unpaid medical expenses. I'm telling everybody this. You have here in Arizona 6 months that you have to get them the receipts and the request. You got to make the request within 6 months. Then
totally.
when it comes time for you to collect on that, that's a separate action. It's not part of your modification. It's a petition to enforce or a petition for contempt. And I would probably go contempt.
Okay. And then if I'm filing, because this is like another thing I'm kind of like wishy-washy on, if I'm filing for contempt, is that a situation where I can also request that he pays the attorney fees since since he's
Yes.
the one in contempt?
Yes.
Love that. Okay.
Yes.
Perfect. Well then I'll just keep doing that and just keep adding everything. And then I did see something where you said like do send a reminder.
Yeah, I think so.
Was
So
okay.
contempt is the willful, knowing violation of a court order. So
Okay.
you're creating exhibits right now. So you're going to write him an OFW and say, listen, our court order states that you are responsible for X percentage of uncovered medical. Currently, as of today, you owe me this much in unpaid medical. This is in our court
Okay.
order where it says this. If you do not pay me or make arrangements with me right now on what this payment plan looks like, I am going to file for contempt. So you've given it,
Okay.
and that's when you get in front of a judge and you ask for contempt and you ask for your fees, you want to show the judge that this is a waste of time, that you have
Hmm.
done everything in your power to work with this person and they have just blown you off, but more importantly, they've blown the court off. They have
Okay.
ignored this court order. They're laughing in the face of the judge, and the judge needs to do something about it.
Okay. Okay, perfect. I think that's it. I'm trying to think. I'm like until next week.
Well, if anybody else has questions, you can absolutely jump in. I'm not going anywhere for the next 12 minutes.
I would like to back onto Andy's question about when you file for enforcement or contempt. Can't you request contempt in your motion as well, and request attorney fees at the same time, or does it have to be a formal?
I like the formal petition for contempt. There's civil contempt and there's criminal contempt. There's different standards that you meet with each of them. For a petition for contempt, it has to be personally served on the person. It gives the judge more potential remedies.
Gotcha. So two separate, but you can essentially file them at the same time if it's bad enough, right? Like if she waits an
Well,
year.
I would do contempt, and then the enforcement is wrapped into the contempt.
Okay.
Contempt is just, contempt means do what you're supposed to do, and there's going to be consequences if you don't. And enforcement is, judge, please, oh, please make them do it.
Gotcha. Okay. Thank you.
Yeah, no problem.
Hi,
Hey.
can I jump in?
Mhm.
Hi. So with regards with what you just spoke about contempt, where the judge is able to do something and there was an enforcement. So that happened with the emergency suspension of his parenting time. She also put in the order that that the mutual no contact order from May is enforced at all times, and he willfully and purposely violated that. And so that's why I put in an official contempt, motion. And in it, I have asked for attorney fees, but it was very general. So then when I put together the specific attorney fees, there were more like allocated costs, including the GAL therapy and my attorney fees, which I don't have right now. Like I'd like to be able to hire an attorney, but I don't have the funds to do that because they all want a retainer of $7,000 or $10,000 because they've seen the history of this case and
Right.
how much litigation is. Yeah, so they like up the wazoo with the retainer. I guess my question would be just I guess so you're just saying to hold off on the consolidation and to advance the hearing date. You don't think it would be in my favor to have because there's so many issues.
I did not say that at all. I did not say that. So what I said is, if you consolidate all of the issues, you're going to have to ask for more time, and it's going to have to be set out. I think, right? That has to
Yeah,
happen.
yeah.
So
Okay.
if you don't mind, then you could consider consolidating. If you have to get done whatever you're going to get done in only 30 minutes, then I'm not sure that consolidating all of those issues will work because I don't think it's enough trial time for you to do an appropriate job on all of those issues.
Yeah, because my question, I guess, is like, why would the judge only give 30 minutes when the respondent has asked for a half a day trial? So she wants to get this done quickly.
Yeah. I mean,
Um,
we never get as much time as we want. Cook County is insanely busy and backed up and slow, like infamously so. Like I know about it here in Maricopa County. So I just think that there's not enough judges to, it's very different than it is like in Washington or Oregon where you can have days long trial. That's just not how our counties operate.
yeah, I feel like the judges go very quickly here. They've already done their
Yeah.
homework. They've read
Yeah.
most of the
Like
petitions,
get to
and
the
then they
point.
just do a five. You get 5 minutes to rule. Get a ruling on it.
Yes.
So this is why I feel like asking for a 90-minute might be too long. If they're, I don't know, but do I?
Lisa, I'm going to go ahead and answer Yanni's question while
Oh,
you
okay, sure,
kind
sure.
of
Yep.
consider your
Okay.
options.
Thank you. Yeah.
Yeah, you're
Thanks.
welcome.
Thank you.
Okay, Yanni, I'm pro se in family court in Massachusetts. I really don't know if I'm making it right. I filed 6 motions and everything will be heard on April 8th, which is our pretrial conference. Or pretrial, but I'm assuming that means a pretrial conference. We're not married. Our first hearing was January 31st. And his lawyer started to say the defendant is a prostitute, always drinking. I'm so shocked with all of this. It's the other way around. Can I file a motion to strike? Okay, so your first hearing was January 31st, and his lawyer said that you were a prostitute. I mean, I wish I could ask you what you said at the time and what the judge did at the time, because that is a pretty serious allegation. And unless that lawyer wants to offer some sort of testimony and evidence, it's a completely inappropriate thing to say. Can you file a motion to strike? Yeah, you can. Now, if that was an evidentiary hearing where the transcript matters for a ruling, then I would be more likely to file a motion to strike. But I'm wondering if you objected at the time or what happened at the time. But I do think, that type of allegation is a great reason to file a motion to strike. If it's a non-evidentiary hearing and nobody's ever going to, I might still file a motion to strike because it's so preposterous that a lawyer would say that unless, there was ample evidence. And even if there was ample evidence, because we do have a lot of cases where one side, might be an OnlyFans model and they earn their money that way. But like the term prostitute, I don't know, that's just not, even if it was technically correct, that's just not the vernacular that we use because it's so disrespectful. It might be something like, a sex worker or a OnlyFans model or a professional, but you want to, it's just very derogatory to say defendant is a prostitute, in my opinion. Especially because you were very shocked. I'm assuming that that's not true and that they were simply literally throwing out information. And then, you can file a Rule 11, and a Rule 11 is a grounds for sanctioning lawyers. So lawyers have certain things that they're responsible to do ethically and legally. So ethically is, the ethics rules and the bar handles that. And then you can't just go pop off in court and make random statements that you don't have any evidence to justify. And so there's something called Rule 11 that you can look at, and you can ask for personal sanctions against the lawyer in addition to your motion to strike, which might communicate very clearly how inappropriate that sort of statement is. So it's a technical thing, a Rule 11 request for sanctions along with a motion to strike, but you can look into it and think about doing that in this case, I think. All right, now, any other questions from our stream, Sarah? Wonderful. All right, then I think we're all set for today. Andy, did you have a couple questions before we go?
Well, if we just have time, if you don't mind.
Mhm.
So one of the things, so like we've filed like a consent decree in our situation because I agreed to a lot of things that I probably shouldn't have agreed to because I didn't want to fight for years in court.
But you got
And I
final
just,
legal decision making on medical, so
yeah, yeah. Well, there was a lot of domestic abuse in the house, and long story short, my 13-year-old was recording it and sending it to his father, who is I have a great co-parenting relationship with, but I didn't know. And then my 13-year-old refused to come home, and then that's when I opened my eyes and was like, what am I doing?
yeah.
Like we're not you realize like you're staying for the kids, but like you're hurting the kids, right? So that's when I immediately was like, we're done. So we filed the consent decree in August. He moved in at girlfriend's house, like straight from our marital home into girlfriend's home, in October. And it was like finalized October 28th. But so we filed the original in August. And then I think in September is when I had like gone with Modern Law, and they were like you could have like asked for some more things, especially financially. Like I gave a lot. And so that's when I was like, hey, like I'm filing an amendment so we can try to work this out and together and talk it out and like file this amendment together and agree, or I'm going to stop the consent decree and then we can start over. Was essentially like what I told him. And so we went back and forth, and then he agreed to file the amendment. So I filled out like it's like the stipulation to amend whatever, and I like updated the parenting time. That's when I went from like 50-50 to like a 60-40 physical schedule. But if I called it 50-50, or if I called it 60-40, like he wouldn't agree. So it was like fine, 50-50, but it's really a 60-40 physical schedule, which child support, like he's paying, like it should be more than double what he should be paying. But it was like fine, if that's what gives me the time with my kids, like that was what was most important to me. So the judge, when he signed like the parenting plan, the consent decree, and like all that stuff, he signed like the updated ones that I had made my updates on, but he didn't actually sign the stipulation to amend that included all that stuff, because that also had like the domestic violence stuff, and that he agreed to do anger management and he agreed to do therapy and stuff, and that's what made me feel safe with agreeing to the 50, right? um so I mean, essentially from what Hannah told me, that's pretty much like a morality clause, like it's hard to like enforce that kind of stuff. um but yeah, so I'm wondering, like, does that even matter? I mean, just because like the parenting plan and the consent decree, like the updated versions were signed, but then there was stuff in the amendment that wasn't actually signed, which she said, I forget what she called it, because she's like, that shouldn't have happened.
Yeah. I feel like without looking at the docs, I'm confused. But
Oh, there we go.
if you have the ability to upload these documents into the Navigator Facebook group, I can take a look and try to figure out what that means.
Oh, okay. Yeah,
Would you
I
mind
can do
doing
that.
that? Okay, yeah.
Yeah. Is that
Upload
like
it.
on this, or it's on the Facebook site?
It's in the Facebook group. So there's a Modern Divorce Navigator closed Facebook group with members only. And you are
Yes, I'm in that.
okay, great. So upload your documents, tag me, I'll take a look at it, and then try to figure an answer out. But I'm feeling a
Okay.
little confused about what was
It is
signed versus
confusing.
what wasn't.
Yeah.
So I want
Yeah.
to take a look at it.
Okay, perfect.
All
I'll
right.
upload it.
Thank you
Okay.
everyone for
Thank you
being
so
here
much.
today. Yep, and we'll be back next week.
Thank you,
Bye.
ladies.
Have a great weekend. Bye.
Thank you so much.